I know we had to do a little bit of scheduling errors with federal court and things like that, so I very much appreciate the court working with me on that and making sure that I was able to be everywhere I needed to be today. I very much
Absolutely,
appreciate it.
and thank you for communicating that to us and working with us. So,
Absolutely.
For sure.
So this is I'm Joseph McCluskey here for Victor Gordon out of this case out of Shelby County, Tennessee. In our brief, we have raised essentially two issues.
Mr. McCluskey, as you notice, we don't have lights, and so I'm our unofficial timer today. Would you like to reserve some time?
I'm sorry, yes, I noticed that we didn't have lights. We had that discussion. I would like to reserve 2 minutes.
Okay.
But I don't think we'll go into all of it.
I'll put this up here for you.
Thank you.
I shouldn't have dispensed with the pleasantries. That's a very important difference in something
Well,
that we're
then
doing
I
today.
did get the rundown
Okay.
when we started this.
I'm sorry, how
meeting.
many minutes were you reserving?
Just 2 minutes.
Okay,
for
great, thank you. Go ahead.
In this matter, we've raised two issues on appeal, sufficiency of the evidence. With that matter, I'll just submit that on brief. It's briefed about as well as it needs to be. The other issue that I think is a little more interesting is whether or not the court complied with TCA 24-7-123, whether or not the court made the specific findings of fact that are required by that statute. What happened at the trial level is there was a motion for the forensic video to come in to be looked at by the judge. Instead of having the hearing on that motion, the parties, this is where it gets weird, they entered a stipulation. And the trial counsel for the defense entered that stipulation, signed off on it. The defense, state, and the trial court all signed off on the stipulation. Normally, I'd say, well, we've got a stipulation. That means that obviously that's it, end of the story. But when we actually look at that stipulation, we look at 24-7-123, it requires not just general or conclusory statements of fact, it requires specific findings of fact. That's what's required under, I think, Part C of that statute, specific findings of fact. The stipulation as it's written simply says, the CAC in Memphis is a valid child advocacy center and meets the requirements of the statute. The interviewer meets the requirements of the statute. Everything meets the requirements of the statute. There are no specific findings of fact in the stipulation as it was entered. Instead, it's all just very conclusory. This meets it, this meets it, this meets it. We submit that the way it was handled in this particular case did not meet the requirements of Tennessee law. If someone were to go back, pull this record, and say, obviously, we can look at the statements, the specific statements of fact, we should be able to say specifically what the interviewer's qualifications are. We should be able to say specifically the qualifications of the center that were used and all of that information. We can't say any of that. If we look at the stipulation, the finding of fact that was entered here, we cannot say any of that. So there is just not enough information in the findings of fact that were entered. Now, of course, we've got the very big problem that trial counsel did this. Trial counsel chose to do this. So is this plain error? There was never an objection at trial. That never happened. So this could only be considered for plain error. So we're submitting that it was a rule of law that was violated, the failure to adhere to that statute, to make those specific findings of fact, and that did violate his rights, Mr. Gordon's rights.
This is different, though, is it not, than most cases we see where there's a failure to object? Because usually that involves counsel just sitting on their hands and not saying anything.
Right.
Here, there was an affirmative, this is something they clearly talked about, thought about, and they affirmatively stipulated that this would be admissible. So how? They
did, and that's where this case specifically becomes so problematic. If the defense had simply not objected, that'd be one thing. Here, like Your Honor says, they affirmatively entered this agreement. And it's very problematic when we have trial counsel affirmatively entering agreement that does not meet the statutory requirements. So the question becomes, if trial counsel is doing something that doesn't meet statutory requirements, at what point does the judge have a duty to say, we have to follow the law regardless of what you guys are agreeing to? You can agree all day long, but if it's not a legal agreement, I won't take it. We're submitting that that's what the judge should have done here, is said, no, this stipulation is not specific enough.
What if trial counsel wanted the interview admitted into evidence? I've personally seen that happen in trials.
Sure, no, and that could very well be the case. I think if the trial counsel wanted the interview in evidence, I mean, there have been frequent times where I've been in trial and I have wanted that, and I agree to a very complicated, detailed stipulation. It takes maybe 5 more minutes to write that and type it out. It's not that much more work for the parties to do, and it makes sure the record is preserved and that the laws are complied with. Doing it this way, it's loosey-goosey, and I never like the loosey-goosey practice of law. And I will stress again, obviously, the performance of trial counsel in that regard is problematic. If trial counsel was making a strategic choice here, that's obviously the kind of things that we would like to hear on the record. Hey, we're agreeing to do the stipulation this way because X, Y, Z. That's good to put on the record so that we, coming after the fact, can understand it. That wasn't done here.
Well, if you, I think the state lays out some tactical reasons or strategy, but if you signal the other side about your strategy, you lose the strategic advantage.
You really do. And so this becomes, it's a quasi post-conviction matter, I'll say, whether or not it's effective assistance of counsel. And if it does get to that point, those are obviously questions we would have at post-conviction for trial counsel. Why did you make these choices? Because again, we don't know if there were valid reasons. We don't know if trial counsel just did this to make life easier. We don't know. And that's where we are right
I
now.
feel like we're having deja vu from our earlier.
I was saying the same thing, yeah.
Well, that's the case, but, I mean, the victim was cross-examined about inconsistencies between the video and the testimony. Do I have it correct?
Yes, there were 2 victims, and I cannot recall, and I apologize, I cannot recall off the top of my head the timing of when each victim testified compared to the playing of their statement. So I think that one of them, there was the opportunity to cross-examine the person after it was played, but I think with the other person, my recollection is one of the girls testified prior to it, so she couldn't get cross-examined on it, but I might be wrong about that.
So if you have your typical hearing and to satisfy the statute, the state has to call, let's just use a one victim example, but call the victim and state, does the interview accurately, was that an accurate recording of what happened? And the victim says yes. The victim somehow gets more comfortable being in court versus the victim suddenly sitting in a courtroom full of a bunch of people and jurors and everything else, and then you've got your strategic advantage and shell-shocked and more effective cross-examination.
Right. And I think that all gets into whether or not this was a strategic choice. Again, we don't know on the record. We can't really say on the record what choices were being made or why. So we can't really say what was done or why.
All right.
If the court has no further questions, I will ask the court to reverse this conviction and remand for a new trial.
Thank you, sir. General?
Good afternoon, Kirby May on behalf of the state of Tennessee and the Attorney General's office. We're asking the court to affirm the judgments of the trial court as well as the verdict of the jury. I'll focus my time on the one issue addressed here by my colleague on the other side. However, I will address briefly at the end the sufficiency of the evidence. Well, first of all, again, we're under plain error. And based on my friend on the other side, I was almost conceded that there could be strategy here. And we pointed out a couple areas where this could be a strategic, tactical reason not to contest the introduction of this. And it was actually very clear through the cross-examination of the witnesses and of the forensic examiner, as well as during the closing arguments, that defense counsel used their 2 forensic interviews in attempts to sow doubt and potential conflicts in their description of the events. And thus, that is a very strong tactical reason to seek the admission of it. However, we don't even get there. The defense, this isn't just where he failed to object. Defense counsel, before trial, the state filed the motion to seek the introduction of the forensic interviews. And before trial, both parties addressed the trial court and said that they had to come to agreement that the defense would stipulate to that introduction of those two videos. And the trial court requested a written stipulation. The parties then drafted a written stipulation. Your honors have it before you. It's Exhibit 1, Volume 7. And we disagree with defense counsel's characterization of the stipulation. It goes through each of the factors broadly, but it goes through each of the factors and show and where the parties both agree that the statute, the forensic the videos would be admissible under the statute, under each of the criteria required by the statute. And again, the statute requires the state to make various showings regarding the qualification of the interviewer, the nature of the recording, that requires the child to authenticate the video and be available for cross-examination. And the stipulation agrees to all that. However, even if we are going to go beyond, this court has concerns about the stipulation, all of that was testified to at trial and in the correct order, which is distinguishing from Stegall, which the defense relies on. Here in Stegall, there was no objection. It just was introduced and it goes forth and it was raised later because it didn't comply with the statute. Here, there's a stipulation, but then both victims testified. If my memory serves me right, both victims testified first. Maybe not as great detail, but they did testify and testified truthfully during their forensic interviews and identified their forensic interviews. And then the forensic examiner testified about her training experience and the protocols of the criminal CAC in Shelby County. And then the interviews were played after, again, the victims were testified and were available for cross-examination. And so the procedure, even if this court were concerned about the stipulation, the procedure was complied with, which distinguishes it from Stegall. But this court has often found, and the Supreme Court has found, that stipulations are preferred. When parties, there are not issues to be contested, stipulations are preferred. And that's what happened here. And by the trial court, by accepting the stipulation, affirmed that it found that everything was in accordance with the statute. And again, at the bottom of the stipulation, it said, all the wishers hereby ordered, adjudged, and decreed by this court. And it signed off on that stipulation. So the defense simply can't show that there was plain error. And that's the standard we're under, because it was never raised or never sought before. And again, and then if you look at this court's opinion in Garens, a defendant invited the court, if your court finds that there was issues, the defendant invited the court to do the very thing they're now complaining of. And the court has declined to relief in those situations. And then looking at the sufficiency of the evidence, I'll just touch on this briefly because they submitted, my party on the side submitted on the briefs. The evidence is more than sufficient. There's testimony and evidence from the two victims. In this case, the defense is not only raising issues as to one of the convictions, as to the rape of a child of A.W. And it's clear from the testimony and the multiple disclosures. There are actually 5 disclosures if you include the trial testimony, 4 disclosures beforehand. 3 disclosures beforehand. You've got the admission to the aunt and the mom and dad, the admission to hospital staff and the police, and then the admission, the forensic interviews that was shown to the, and then finally the trial testimony. And it's very clear. This is a situation involving A.W. where she was 5 at the time, where there was unlawful sexual penetration of the victim. The sexual penetration was cunnilingus, very clear in the record and identified in that. And then cunnilingus is defined as placing a mouth or tongue on or in the vagina of another. And this court has found that penetration of a vagina by the mouth or the tongue is not required for a sexual act to constitute cunnilingus. However, even if the court has concerns about that, the testimony was very clear that the victim's clothing was pulled down by the defendant, and that he kissed and licked her crotch in the crotch area, which was described as where pee comes out. And these are 5 and 7-year-olds that describe that event. And the defendant even puts himself in the scene and says he admitted being in that trailer playing mommies and daddies with the victims. This is clearly rape of a child and meets the definition. And taking the light most for the state, we've asked this court to affirm the judgment of the trial court and the verdict of the jury.
Thank you, General. I think you have rebuttal time, sir?
Very briefly, I
Yes,
doubt
sir.
I'm going to use the full 2 minutes. The state, I believe, has conceded a very big point. The statute 24/7/123, Part D, the court shall make specific findings of fact on the record as to the basis for its ruling under this section. The state specifically said that when we go through, the court went through the factors, the state described how the court went through the factors, not specifically. The state didn't say specifically. The state said broadly. I think the state has to concede here that the court did not make specific findings. They made broad findings, and that does not meet the statutory requirements here. So for those reasons, we're again asking that this be reversed and remanded. Okay. Thank you.
Thank you, sir. Thank you, counsel. Thank you for your briefs on this matter. You good?
I think so. I'll let you know.
Okay, all right. Madam Clerk, if you call the next case, please.